Well, welcome to the Estates Made Simple podcast. My name is Gordon Vanderleek. I'm the founder and managing partner of Vanderleek Law, and my co-host here today is Jenna Carvello, and she is the founder, I think I can say that right, founder of
Yep.
Guardian Estate Company. We're on a mission to simplify the world of estate administration and ensure executors have the right tools to do their job. So thanks for checking in, either listening or viewing. And yeah, interesting topic today about registered education savings plans, or RESPs, and its application in estate administration. So maybe to kick it off, Jenna, why don't you introduce I guess, some concepts and introduce the topic of RESPs.
Yes. Well, thank you. Nice to chat with you today, Gordon. So RESPs, as Gordon mentioned, registered education savings plans. Many parents or guardians set these up on behalf of their children or grandchildren for the benefit of them going to school later on in their years. So there's a couple of different rules the government has in place with respect to these plans. There's somebody called a subscriber, who is the individual that sets up the RESP and who also can contribute into the RESP plan on behalf of one or more beneficiaries. There is a maximum contribution limit that the CRA matches. So it's up to 20% of $2,500 per year. So you can actually get $500 from the government every year. You put in, I think, to a maximum of 7 years, if my memory serves me. There is a lifetime maximum contribution limit of $50,000 per beneficiary during the plan setup. And growth and grants are taxed in the hands of the beneficiary rather than the subscriber. So this can benefit, if you have a student taking out funds from the RESP, they're obviously or most likely at a lower tax rate than the parent or guardian would be. And so you often get some tax savings at the end of the day as well.
Right. And so in a situation of setting up these RESPs, what are the different types of RESPs? I think sometimes I hear a reference to, like, just for an individual or sometimes a family.
Yeah.
What are the options available that executors may see if they're coming across an RESP as part of an estate?
Yeah, so as you mentioned, there's two main plans. There is a third called a group plan, but most institutions only agree to set up single or family plans. And so, a single RESP is for a single named beneficiary. Family RESP is for one or more beneficiaries. So if you had multiple children, it's good to have them under a family plan if the circumstances warrant, just because you don't know who will go to school and who will
Yeah.
be benefiting from the plan. So you can pool the funds, and then when the kids get older, they can decide who's going to be using them. So those are the main plans that an executor would come across and need to be dealt with in the estate. And I think this is an interesting topic because it's often surprising when an executor learns how an RESP is actually dealt with.
Yeah, and let's talk about that. Because one would think intuitively, if I'm setting aside money for a child or a grandchild, well, that's where it's going to go, right? But the interesting aspect of RESPs, looking at it from an estate perspective, is that if there is not a successor subscriber, that's a tongue twister, named for that RESP, it falls into the residue of the estate. The residue being it's part of the general body of the estate and would be distributable to the beneficiaries after the payment of all expenses, right? So in an example where there are 3 children and let's say mom is surviving parent or is the last parent to go and has set up these RESPs, and the will says divide equally between the children, but there's one RESP in one of the kids' name, it sets up that question of, well, does it go to that kid or does it go into the estate and therefore divisible by 3 in my example? So I guess contrary to popular belief, is that you need, or if there isn't a successor subscriber that is named for the RESP, it falls into the residue of the estate. I think the other implication is, of course, in that situation, there's the possibility that grant money can be returned to the government, because, as you've indicated, the government has created this incentive system that if parents or grandparents put money aside for post-secondary education, the government is encouraging that by contributing some money to that. So we want to, obviously from a planning perspective, want to ensure that the funds stay for the benefit of the child or the grandchild. But from the executor's perspective, what, do they have that responsibility, right? And how much has to be returned would be something that they're going to have to grapple with, and then figure out what happens to the investment of that money. Because, as you've indicated, the money grows within the RESP. I think that's one of the advantages. You can put some money in, and while you don't get a deduction like an RSP, you get this contribution, and the money can grow tax-free within it, but then there's a tax consequence when it's pulled out. But if you're effectively pushing some of that income and that growth to the child or grandchild, then effectively you can do some income splitting, if you will, and obviously first and foremost supporting maybe the parent or grandparent's desire to see that child or grandchild pursue post-secondary education. So I think the takeaway would be that the executor needs to make a determination. You can't just make an assumption to say, oh, that's an RESP for the kid, well, I guess it goes there. You got to dig a little bit further and say, have they complied with all the rules to say that's where it does go? And who has the authority to make a contribution into the plan? Is there anything in the will that deals with ongoing contributions? If the parent was putting $100 a month into an RESP, does that have to continue? What are the obligations there? Is there any direction in terms of what the person intended and what the will states? So it can be a bit of a tricky issue, and legal advice may be needed to determine who has rights to it. And I think the other interesting thing regarding the RESP would be, what are the claims of creditors, right? It makes a big difference. Are these monies segregated for the benefit of post-secondary education for the child or grandchild, or is it part of the residue of the estate that might be available if the estate is insolvent and the creditors are looking to be paid, right? Can they attach to this money or not? That would be a highly important consideration to determine their rights, and they may be very interested in getting to the bottom of it or challenging an executor's assessment of who has access to that. So I think it's one of those areas that can be often overlooked and could be a source of liability if in fact it's ignored and or the wrong action is taken in regards to who controls it and where does it go.
Well, and you alluded to the fact that the government grant money would likely have to be paid back to the government if the RESP was transferred into the estate upon someone's death. But I don't know the answer to this, but I would assume that the government would have first priority over that grant money if the estate is insolvent. Do you have any comments on that?
Yeah, but then there's what about I think they would in terms of the return, because it would be the net amount that would end up in the estate.
Yeah.
But the issue would be, what if the child's going, hey, wait a minute, that was supposed to be paying for my tuition.
Yeah.
But it didn't, right? So definitely something to think about and review as you're looking at your own will to say, do I have the proper clause in the will? I know we always include a clause that says, hey, I want my executor, which might be surviving spouse and or the person named, to be the successor subscriber of all RESPs. And of course, this is only applicable if they exist. If they're actually used up and shut down by the time somebody passes away, it's a non-issue on that. But whether it's part of the residue of the estate or not is a highly relevant consideration for the rights of creditors, right? Because that's what they have to attach to. So it can make a difference in certain circumstances if there are creditors who are looking to be paid out of the residue of the estate. What would be, as you're reflecting on it, sort of best practices with regard to RESPs?
Yes, well, this is actually top of mind after having my second child. I'm adding my second child onto our RESP plan. So it was a single, and now it's become a family plan. But some of the best practices would be to set up joint subscribers. So my husband and I are both subscribers on the
Yes.
plan. If one of us passes away, at least there's someone else still managing the plan and carrying it forward. So that would be a tip for the listeners. Another tip, of course, as you mentioned, is to include a clause in your will to ensure that if you are a subscriber of an RESP, you do have someone as a successor named that can continue on the plan to avoid the RESP falling into the estate. And then lastly, I would say, if you don't need the RESP any longer, if your kids are already grown up and you still have funds in that RESP, consider collapsing it before something happens to you, rather than having your executor needing to deal with that account.
The other thing that maybe I can add to that, because I know we do a fair bit of work with families that have children with special needs. In some cases, if a child, maybe as a result of an accident or a traumatic brain injury, um, was planning on going to post-secondary education, but as a result of the disability, the event, is now no longer able to pursue post-secondary education. And if they qualify for the disability tax credit and have an RDSP, a registered disability savings plan, so one of these other plans that starts with an R, we can roll over from an RESP to an RDSP. Obviously, that's a very limited set of circumstances, but you can also investigate whether rollovers are applicable for these unused funds. And investigating that would be appropriate, because I mean, certainly these amounts in the RASPs can accumulate to a decent amount of money, right? If you
Mhm.
start early and they're invested and grow, they can be a sizable amount that is worth giving some thought to, and more importantly, that one's intentions get carried out.
Yeah,
Yeah.
definitely.
So thanks for that. I think a good reminder for all of us to look at our RESPs, and as executors to determine whether in fact what your responsibilities are for the RESP, and get legal advice with regard to that. So we want to thank everybody for joining us. Please subscribe. That helps us grow our audience, spread the love and the word about estates made simple, and just tune in to wherever you subscribe for podcasts. Our next episode is going to be talking about administering an estate where beneficiaries cannot be found. They're missing. I think an
Ooh.
interesting file. I know we had an interesting case a while back dealing with this very issue, so I'm excited to talk about it. So again, if you subscribe to our videos on YouTube or to the podcast, you'll make sure you won't miss that episode. So thanks for tuning in. And of course, as always, if you have any questions on this, contact either Jenna or I. We'd be happy to engage in a conversation about your specific situation.
Thanks, Gordon. We'll see you next time.